ಟೋಟಲ್ 12. ಸರ್ ಕೇಳಿಸ್ತಿದ್ಯಾ? KMK ಸರ್, ಶೆಟ್ಟಿ ಸರ್.
ಕೇಳಿಸ್ತಾ ಇದೆ ಮೇಡಮ್.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಕೇಳಿಸ್ತಾ ಇದೆ. ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ 12 ಇಂದ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್? ಟೋಟಲ್ 12 ಇಂದ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಓಕೆ ಸರ್. Yes. Yes.
tomorrow. Yes. Next week. Next week alla kodi. Unless there is an urgency, other matters you give that memo. Professor helbidi belge tagali. Next week, yes, tell. Next week. But Monday, Tuesday, unless there is an urgency by today or tomorrow, other matters will come usually by next week. Yes. Tuesday. Yes. No, that you have moved before me this much. Verify Monday. Yes. Nodri date ಕೊಟ್ಟವನು date ಕೊಟ್ಟವನು ಮೆಮೊ ತಗೊಂಡವನು ಆ ವೀಕ್ ಅಲ್ಲಿ specifically given date and that date it has to be posted. Other memos ಆ ವೀಕ್ ಅಲ್ಲಿ ಅರ್ಜೆನ್ಸಿ ಇಲ್ದಿದ್ದವ್ ನೋಡ್ಬಿಟ್ಟು ಆ ವೀಕ್ ಅಲ್ಲಿ ಯಾವ ತರ ಪೋಸ್ಟ್ ಮಾಡಿ. Execution when it is dated. Date of execution. 15/11. We'll have it on 12th. Yes, 12th. Yes. What is that? Yes. What has happened to that injunction suit? The injunction is dismissed. Then what is there? Yes, next week. Yes. Next week, clear.
Page wise adjournment. Page number 1, serial number 1 and 2. Page number 2, serial number 3 to 7. Page number 3, serial number 8 and 9. Page number 4, serial number 10 to 12. Page number 5, serial number 13 to 17. Page number 6, serial number 18 to 21. Page number 7, serial number 22 to 25. Page number 8, serial number 26 to 34.
31.
But
Yes. No objection. At the request of counsel for that appellant, this is matter of 2 weeks.
page number 9, serial number 35 to 41.
38.
Yes, yeah.
Yeah. No, you are appearing for? No, yes, you have no objection. And then their application for vacating. No, you after taking that interim order, you want to engage the senior counsel and he is suffering. Vacating the application is there next week. That will decide. Wait. Yes, pass on. When the matter is reached, you can mention. Yes.
Page number 10, serial number 42 to 47.
40.
No, 3.
Serial number
43, sir.
43. Yes. IA for additional documents as stated. At the request of counsel for the appellant, this matter after 2 weeks. 44 will not admitted. Yes, next week. 2 weeks. At the request of counsel for the appellant, use this matter on 23rd.
Page number 11, serial number 48 to 50. Kumar Kapi.
Yes, appeal not yet admitted. At the request of counsel for the appellant, use this matter of 2 weeks. Yes. Yes. Yes, you serve him. Yes, at the request of counsel for that respondent caveator, this matter of no, next week it will come. Yes. Yes.
Number 1, for order serial number 1, Sriram P. Nayak,
Ram T. Nayak, general order, roster bench, non-furnishing of the cover issue notice to the respondent for first time. Each time he is granted to do the needful.
serial number 2, R.P. Sadashivappa,
Yes. He submitted that. The sole appellant has died on memo hakidira. So memo, the appellant has filed a memo. Dated 8/11/2022 reporting the death of the sole appellant. Died on 21/2/2022. It's no application for bringing LRs has been filed within the time. Hence, appeal is abated. Dismissed as abated.
serial number 3, Kandekar for appellant,
Yes.
Individual state purchasers. All the individual state purchasers have been paid separate.
No, that what is the suit?
Partition.
Suit for partition. You are a defendant.
One of the defendant.
You are one of the defendant.
Suit for declaration.
Suit for declaration. That against that you are all holding different extents.
Different state, individual state. That matters, yeah.
Yes. Submission of learned counsel for the appellant in respect of office objection is accepted. Adonde the office objection. Office objection is overruled. Issue notice. Please this matter along with that so on. Next matter is also same. Yes, same matter.
number 5, K. Narayana Swamy for appellant,
Yes, ma'am. What to do then? If it is dismissal of the application, then you have to file a writ petition. Yes, GM, yes, similar matters, somebody has filed a decision order. You want to withdraw? Huh? MFA can be converted as a writ petition. That the prior has to be, interim prior has to be paid in that. You go through similar this thing. You note down that this thing. Yes, on that basis, officers raised an objection. Yes, learned counsel for the appellant has filed a memo seeking leave of withdraw this appeal with liberty to approach appropriate legal forum. The memo is taken on record. The above appeal is dismissed as withdrawn.
serial number 6, Vinanaji Tigadi for appellant,
Lord, 1 week time may be granted, my lord, to take the process.
Yes, week's time is granted to the needful.
serial number 7,
Please, ma'am.
Swamy MS for appellant, Sebastian MA,
Filing of paper book, Narasimha Swamy.
And for the respondent, please.
Yes, where is? Also,
serial number 8, Nagarajappa A, KP Saravana Madhav for appellant, Ajit Kalyan,
yes. Learned counsel for the appellant press 2 weeks time to comply that of subjection.
serial number 9, Sokareddy for appellant, Vidya S,
For furnishing a PF, issue correct notice, appeal address memo, issue notice to the 12 and 14, second time, acknowledgement for cover received for respondent number 10, 12, 14. Who has filed an application for this thing? You are appearing for whom, madam?
Since it is an export.
What is No, that you have not obtained any interim order in that. Why? Why this court has not granted? What is the suit, mister? Oh.
We are the one of the purchasers. 2006 we have purchased the property to supply. Issued by 2016. Right, we have the notice was not served.
No, you see, you are the purchaser. 2006. It is immaterial. You are the purchaser. Now that suit is decreed, your right has to be established in that final degree proceedings. If the purchaser right has to be determined in the final degree proceedings, whatever that share will be allotted to your vendor, you can seek for that reallotment. You have no right in that partition suit, mister. You can't say that this thing. What is your right? Your right of the purchaser only limited to that your vendor. You are not in a necessary party. You can implead in that final degree proceedings, seek for your share. You can't ask them to stop entire their this thing. Who has sold? Who is that your vendor? Defendant number? No, that huh? No, but who has sold? Whether plaintiff has sold, defendant has sold. Dependent number 6 to 12. You go and anyhow you are in a party in that final degree proceedings. Then. No, that is different. No, mister. If purchaser is concerned, you are right only in respect of that your vendor. That can be determined in the final degree proceedings. That is the law. In final degree proceedings, the property's share of that your vendor will be allotted to you. No, that is always like that, mister. No, mister. Person who has sold the property, he'll keep quiet, colluding with that other members. Since you have purchased the property of joint family property, you have to suffer. Only remedy for you to that, you have to go for a final degree proceedings. There is nothing wrong in that, mister.
They are aware of the entire fact. That was converted. Suit by 2016.
That is all immaterial, mister. In fact, joint family properties, is it your case that it is not in a joint family property? You are not disputing that it is not a joint family property. Only thing is that you are entitled for the share allotted to your vendor. What is that ground, mister? In partition suit, that is the only ground. You can't go beyond that. No, you cannot say that is left to them. Why can you say that collision?
Several properties are there. Several properties are there.
Mr. Counsel, you are an outsider. You have no right. You can claim the property which is sold to you has been also included in a suit schedule property. You are right in the final degree proceedings. Otherwise, you have no right. That is the law. Yes, madam. Yeah, before that, FDP court pass any order, then you can challenge it. Yes. week's time is granted to do the needful.
Serial number 10, Maheshwarappa for appellant. Telugu Chandrasekhar.
Dismissal of an appeal in view of non-compliance of office objection for court time. What is that office objection? Sir? Acknowledgement for having served to be certified copies of the plaints of impugn OS to be filed. Relevant copies as OS to be filed. There are an office objection, sir. You have to comply the office. Not second time, sir. This has been raised in that first time itself. You have not complied. 3/8/2021. Fourth time you have submitted. Today it is posted for dismissal. Not one, Mr. You have seen that there are a number of office objections. Not grant. I will just say 1 week because otherwise today it is posted for dismissal. Yes, either if it is not complied in terms of that order, I will dismiss it. Yes, release this matter next week.
Serial number 11, Raj Singh for appellant.
Yes.
And I feel that this has to be posted before the division bench at the right of the property is more than 15.
When you have complied that office objection? 16/12/2022.
More office objection. One ಮಾಡಿದರೆ ತಿರ್ಗಾ 3 ಆಗಿದೆ.
ಇನ್ನು 3 ಇದಾವ್ರಿ. Detail valuation para to be stated.
24, paragraph 24, I was specifically stated about the value of the property also.
See, that is no, Mr. It is not the way of filing that appeal, Mr. It has been prescribed. There should be a one para for a valuation. Yelli there, 25. You have to be made a caption as for an evaluation. Under that, you have to say, appellant has valued that above appeal as purpose of the court jurisdiction. Court fee. This is 33 lakhs. And then it has to go before the division bench. Division bench is there. Details valuation para to be stated. Andre adrne avaru helidare bandu adike one captions ಬರಬೇಕು. ಅವಾಗ ಅವರಿಗೆ ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ easy to that see, otherwise it look like in one of the ground. See, 23 ground 24ಕ್ಕೆ ಅದೇ para ಹಾಕಿದ್ರೆ it is appears to be that it is one of the ground. It is not for an evaluation. You make it no, you correct it and that office will raise an objection that it is before the division bench, then I will pass an order. It has to go before the division bench. We'll have it on Monday. Yes. Correct it in that office, then they will raise that objection, then we'll, yes. I'll release this matter on Tuesday. By the time you do it, officer,
Serial number 12, K.K. Vasant for appellant.
fixed time is granted to do the needful.
Number 13, Niraja Karan for appellant. Vishwanath Shetty G.
Yes. Yes. No, if it is even, then probate should. If the valuation is more than less than 10 lakhs, the appeal is lies to that. No. If it is in a regular civil suit, it is under that probate, and where is that appeal provision under that act? it is filed under that 276 of Indian Succession Act, then against that judgment and degree, which provision is provided to appeal before this court? No, that under that. On the order of the district, every order made in the district will refer to power confirmed will make a subject to the appeal to the High Court in accordance with the provisions of. You have to be 90 CPC along with the 299 ಅಂತ ಹಾಕ್ಬೇಕು ನೀವು. ಅದಾಗದೆ ಇರೋದಕ್ಕೆ ಅವ್ರೇನ್ ನೋಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಇಟ್ CPC ಒಳಗಡೆ ವ್ಯಾಲ್ಯೂ ಇದಾಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಮಾಡಿದ್ದಾರೆ. 230 I lost that office 230 pass out. Then I will overrule and yes, 230. It is maintainable, Mr. It is appeal is maintainable before this. But what is that? Even if it is 10th and it is not that under CPC, it is under that Succession Act. Against that order of the district court, they have to come to that High Court on. Instead of mentioning section 299, she has mentioned only that CPC. Therefore, office has raised. Pass on. I will ask them to verify and then.
Number 14, category 80 for appellant.
Non-compliance of the office objection second time. Sheshigiri. Pass out.
Number 15, VP Siddaramaiah constitutional.
Yeah, no, what is that article, Mr. Huh? MFA RPD, MEC, ಆ ಬೆಂಚಿಗೆ ಹೋಗ್ಬೇಕು ನಮ್ಗಲ್ಲ ರೋಸ್ಟರ್ ಚೇಂಜ್ ಆದ ತಕ್ಷಣ ಅವ್ರ ಮುಂದೆ ಹೋಗ್ಬೇಕು ಅದಕ್ಕೆ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಗೋ ಬಿಫೋರ್ ದಟ್ MEC ಕೋರ್ಟ್ ಮಿಸ್ಟರ್ ಇಸ್ ನಾಟ್ ಬಿಫೋರ್ ಮೀ. Yes. None appear. Release this matter of office objection. None appear. Release this matter of 2 weeks.
Number 17, yes, appeal for litigation or connected matter.
Connected.
Connected MFA CPC ಇದೆ ಸರ್ ಸೀನಿಯರ್ ಬೆಂಚ್ ತಾವಿದ್ದೀರಾ
No, then you have to take notice. Where is that order for service hand summons? To ensure that hand summons written by quickly issue to the person. If there is any failure, consent shall fail in submission note with explanation. Yes, where is your affidavit? No, he is settled in abroad or he has went for some tour. ಮತ್ತೆ abroad ಗೆಲ್ಲರೂ ಹೋಗಿದ್ರೆ ಮತ್ತೆ ಬರ್ತಾರ ಅವರು. Is it your, what is your information? ಅಂದ್ರೆ ಅಬ್ರಾಡ್ ಅಲ್ಲಿ ಇದಾರೆ ಅಂದ್ರೆ ಹೋಗಿದಾರ ಅಥವಾ ಅಲ್ಲೇ ಇದಾರ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಂತ. ಮತ್ತೆ ಅದನ್ನ ಹೇಳ್ಬೇಕು ತಾನೆ. Then only you can take in a notice. Court has said then hand summons. If he is coming back, then you can serve any hand summons later. Your affidavit is not clear, mister. Court has asked you to file an affidavit, but it is not. You have to file a better affidavit. Whether he has, if it is settled there, then you have to take in a notice. If he is, he was in abroad for some tour or he's returning back, then you can serve that hand summons. Yes, learned counsel for appellant praise. Each time to file in a better affidavit. Please this matter next Thursday.
If you look at the application matter, serial number 18, indicate the age of the appellant.
IA 130 day in filing in LR application so and so. Notice ಹೋಗಿದ್ಯಾ? Yes, issue notice on IA 1, 2 and 3 of 2022.
Number 90, yeah, Subramania for appellant, H. Ramachandra.
In filing an appeal. Notice service ಆಗಿದೆಯಾ ಎಲ್ಲರಿಗೂ? You are the only respondent. Yes, you have any objection for condonation of delay? It will come to that admission only after condoning the delay. Therefore, I am saying. Yes, there is a delay of 20 days in filing an appeal. IA 1 of 2019 is filed for condonation of delay. Peruse heard the learned counsel for the parties. Peruse that affidavit filed along with that application. For the reason stated in that accompanying affidavit, delay of 20 days in filing an appeal is condoned. IA 1 of 2019 is allowed. Yes, post this matter for admission.
Yeah, for appellant, B. Vachal.
Yes.
This year, they are employing an interim order, injection, and the matter evidence is also recorded of the plaintiffs. There, I have clearly established in the deposition itself that they are not the partners of the particular enterprise, which has got an alternative site from Mediation.
Yes.
And this particular alternative site has been already.
So what is the suit? Yes, is it a plaintiff appeal or a dependent appeal? Dependent appeal. No, where is there any order? Then. No, heard admit. No. How can it be disposed of now, Mr. If you are ready, paper book has to be filed. Matter has been heard. Your interim order has not been granted by this court.
In the clear case, they have really before the court, but they are not departments.
I don't know that. No, I will come to that earlier. No, I'm not on that point, Mr. This court, no, there is already an order. After applications will be posted along with that admission. Court has only admitted the case. Now that matter has to be, you have to be filed in a paper book, then you have to be passed now. File in a paper book. Office is directed to secure original records from the trial court. Learned counsel for the appellant has undertaken that he will file in a paper book within 2 weeks. Yes. 2 weeks ನೀವು ನಾಳೆನೇ ಫೈಲ್ ಮಾಡಿ ಅವರಿಗೆ ಸರ್ವ್ ಮಾಡಿ, then it will posted in the post this matter for hearing.
Okay, Shamil.
Acknowledgement having served copies to the council. Only one respondent. Yes. There is a delay of 1 day in filing an appeal. IA 1 of 2022 is filed for condonation of delay for the reason stated in the accompanying affidavit. Delay of 1 day in condone. Yes. What is this appeal? Huh? No, suit for their injunction. Dependent appeal. Suit. No, suit for, no, first we'll give in a brief facts. Yes. Suit for injunction. And then application is allowed. No, application is allowed. Yes. No construction can be made without the permissions of the local authority. No, that is also in the local authority. You see, law says that you have to take a permission and construct. See, you are constructing that properties or the public constructing the properties without taking the permission. It is contrary to law. It is different. Court cannot grant such a relief contrary to the law. What is wrong in that? It is correct only. No, if no, then it is not entitled under the law. Can the court direct? No, Mister, if you want to make any construction, you have to take in a permission from the BBMP. It is in a law. Then court say. No, if you want to make any construction, direction of the court is that it has to be done in accordance with law. Nothing wrong in that. If it is your property, this is B Kata, we are not concerned with it. No. I see the court cannot be permitted to construct that in contrary to the law. You cannot. No. Leaving setback, it is true, Mister. Can you make any construction in that B Kata property without, if BBMP grant any permission, you can construct. That is the fair. It is a very reasonable order. That cannot be. See, suppose if you want to construct somebody's property, BBMP will say that you are not an owner. Then you can ask the court to give a permission. Can it be given? No, if you record that undertaking, it is nothing but I have permitted you to go on construction, Mr. It is taking an order by see, court has not prohibited you to construct. If you want to construct, you do it in accordance with law. What is wrong in that? Yes, that is the law. That is the law. Who said, Mr.? Property is coming under that BBMP and BDA, you have to take in a permission. Without taking a permission, you can construct the property in that BBMP limit. Which laws? Show me that judgment. Yes. Anyhow, condone that. Yes. Even. That is what that my judgment. Yes. Call this matter next week. Yes. Tuesday. Yes. Yes.
Number 22.
Yes, Mr. Do you have any objection? Yes. All respondents heard. Yes. Delay of 4 days in filing an appeal. IA 1 of 2022 is filed for condemnation of delay. Heard the learned counsel for the parties. Peruse that affidavit. For the reason stated in that accompanying affidavit, delay of 4 days in filing an appeal is condoned. IA 1 of 2022 is allowed. Yes. Yes, post this matter for admission.
C. Ravi Kumar for appellate.
Condemnation of delay in filing 79 days in appeal action. IFR stay, IFR filing number 34 days with respect to the deceased. Notice is not ordered. Who is that? Sole appellant is dead. Then notice is not necessary. Are you filing an wakalat for that LR? Then we will allow that. Why do you want to? Who has to then object it? Who are that LRs? Where is that application? Yes. 1 A is who? Huh? Wife. B, C, D, children. Huh? Yes. There is a delay of 79 days in filing an 32 days in filing an IA 1 of 2022 bringing 32 days delay in filing an application for bringing a loss of deceased sole appellant. For the reason stated in the accompanying affidavit, delay of 32 days in filing an LR application is condoned. Consequently, IA 2 of 2022 setting aside that appointment is also allowed. IA 3 of 2022 is allowed. LRs of the deceased appellant is permitted to come on record. Learned counsel for the appellant is permitted to amend the custody. Yes. 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 Where is the other side? He is not there. Where is Nagraj? You want time? Yes.
संतोष ये बंद करो तो जरा.
For respondent, learned counsel for the appellant press 2 weeks time. It is matter of 2 weeks.
Number 25, MS Nagaraja for appellant, Sachin C.
Yes. Yes.
They are trying to Wakala, they are appeared, but they are not later they contested. They are out, they are executed. Having the knowledge about the definition of proceedings. They have received the execution, they have received the notice from the execution court. Recently, then they have opted the.
No, that who are that plaintiff? The defendant. No, no, appeal is filed the defendant. Defendant appeal. Suit for?
Suit for declaration, possession, and mandatory injunction for demolishing the house and handing over the possession.
Yes.
Survey number 4, measuring 1 acre.
Wait, mister. Suit is decreed.
Decree.
You are placed on ex parte. Yes. Huh? I will see that. Where is that? Advocate of a defendant is dismissed. Defendant number 3 deleted as a court by order. Only 2 defendants. Yes. You have been represented by counsel. No evidence, nothing.
They are not had evidence, they have not filed a constitution.
Yes. Suit is decreed. Wait. Now I am deciding on that application. Then where is your application for condonation of delay? Yes. Where you have stated that? Yes, read.
Due to the absence of offensive, the plaintiff has proceeded to report the evidence. Court has secretly issued only on the basis of the evidence of either cases. In fact, the document produced by the plaintiff and the clearly shows that.
No, that is all on merit. Except that since they have not done. Yes, Mister, what you say about the delay?
Same law. That you have to fight my objections. I fight my objections.
No. No, who has filed that suit? This is very.
As it is speed, injunction can be same law. In that suit, I can register. Say that this suit is also taken. And I suit.
No, when that suit has been filed?
2014. You have to paragraph of objections.
No, that OS number? 7.
It didn't say same suit. Then I have filed. Now what happens? They don't have that's dismissed. 2011 2017. 2011 2017.
Yes.
Such is the case.
Which is the place this is? It is in Bangalore or outside? No, what that claimants are doing, defendant are doing, mister? What are the defendants are doing? No, there's, see, they are doing, I just want to see, they are an illiterates or they are, but see, what is that business or they are doing, they are police or what? Then you have, when that suit is pending, you have filed in a suit, you have engaged the counsel, you are aware of that. That also you have not proceeded.
Then they said that they contend that they are already compromised.
Tomorrow, I think even this appeal will not proceed. It appears will again that they will not contact you, then you will not also prosecute the case, they will dismiss. No, don't go to that merit, Mr. Till you are in the delay. First, you have to come out from the delay. Then we'll.
ಅದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಗ್ತವರೆಗೂ ಅವ್ರು ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ರೆ they would have filed immediately the appeal they will definitely they will go to file this intimation ಬಂದಿದ್ದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ನೋಟಿಸ್ ಬರುತ್ತೆ ನಾವು immediately we have filed an appeal.
Oh, it is not that you are not aware, Mr. You are filing other suit and prosecuting. There is why. See, otherwise straight away I could have been. After he has brought to the notice, you are very diligent and you are filing the suit.
Correct, my lord, ಅದು ನನಗೆ ಅದು since my lord ಈ ಸೂಟಲ್ಲಿ ಅವರು ಯಾವ ಲಾಯರ್ ಮಾಡಿದ್ದಾರೆ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿ ಯಾರು ತೋರಿಸಿದ್ದಾರೆ ಮಾಡಿದ್ದಾರೆ. ಆಮೇಲೆ ಏನಾಗಿದೆ again there is some
What is that? What is that case on merit, Mr.? What is your?
Say government land,
Yes.
Say government land.
Yes.
My lord, the site, my lord, the government has acquired the said land in 1972-73 for the purpose of the allotment of size. The houseless people under purchase.
Where is that notification?
ನನಗೆ ಅದೆಲ್ಲ ಕೊಡಿ. These undisputed facts.
You have not produced there. Even I am giving an opportunity because the persons are houseless persons. If it is land is acquired, I can protect them. You are not producing. Oh, the declaration has been granted, Mr. You are saying that undisputed price, there is a degree in their favor. That you have to show me some documents. See, you have not appeared before the court and contested. Now, even you are not showing the documents to show that land has been acquired. Where is that acquisition notification? Now, is there any notification for acquiring that land? Mr. Nagaraj, you have argued that this land is acquired. You stand by your notification putting. Then you apply it and produce it. You are keeping all the documents. If the land, see, land is, if it is acquired, you are aware that, but you are not applied and producing the documents. If it is land is acquired, see, Nagaraj, if acquisition notification won't produce Madra, he is out of the court. He cannot be, the suit is not maintainable. But
in the meantime, they obtained an order. Instead of 21/7 for execution to warrant.
now that matter is posted for when?
ಅದು await warrant 27 warrant. ಈಗ warrant they have already received the warrant. Commence the building.
Yes. Heard. Karnataka Council for the parties on IA 1 of 2022. For condemnation or delay of 107 days in filing an appeal. Karnataka Council for the appellant has submitted that. The appellants are illiterate. After engaging that after they are engaging their counsel, they have not contacted their advocate and advocate has not sent any intimation regarding that disposal of the case, even therefore they are not aware of that disposal of the suit. They came to know only after the execution petition has been filed. Hence, there is a delay in filing an appeal. Learned counsel for respondent has filed an objection stating that after service of summons, the appellant defendant has represented by their counsel. It is not an ex parte degree. He further contended that during the pendency of this suit, the appellant defendant has filed independent suit in OS number 7010 of 2014 for injunction against that plaintiff. Therefore, they are aware of the proceedings. Hence, he sought for dismissal of the application. Heard the learned counsel for the parties. It is not in dispute after the service of the summons in suit. The defendant appellant has engaged their counsel. Written statement file madidira. Thereafter, it appears they have not contacted their counsel. No written statement has been filed. They have not adduced that evidence. Since they are an illiterate villagers, they are not aware of the proceedings and there is no intimation received from their counsel. In the interest of justice, in the interest of justice, delay of 107 days in filing an appeal is condoned. IA 1 of 2022 is allowed. You should file a notification, then I will consider IA 1 of 2022. Where is that order for demolition? What is the stage, Mr.? No, that if it is demolished, then his appeal is become infructuous. Only that if you show that if it is acquired land, it is not your property, then
I understand.
let him that. Yes, that is that. Yes. Otherwise, he has no right because his claim is only on the basis of that government. If it is not government land, then it is either your property or somebody, but it is not his property. First, convince me that it is a government property. Yes, when do you want?
In the meantime, they are not precipitate money. What are the
Yes.
How to precipitate?
The respondents are directed not to precipitate the matter till next date of hearing. You will give that specific date, Mr. You cannot be taking that benefit. When do you want? Yes, list this matter on 23rd.
Number 26, Varun for appellant.
Yes. Yes. Notice. Notice. There is a delay. Notice. Yes. Issue notice.
Matters. Number 27, HR Keshava Reddy for appellant. Pasha, Surendra Kumar.
Lord, I appear for the respond number 1 and 3 in this matter.
What is this, madam?
This land was acquired under the Injunction Act, and then reference under Section 18 was filed by the landowner, and compensation determined was enhanced from 45 to 75 rupees per square feet, in spite of there being no material on record for higher market value. Now the landowner has filed this appeal. So appeal was filed in 2012, and now it was heard on various dates, several dates, and now he has filed application for production of additional documents. And
What
we
is
have
that
filed
additional documents, madam? Is
We have
there
filed
any
objection.
adjacent lands property?
No, Milord, but basically, Milord, these documents, this application is filed under Order 41, Rule 27.
Hmm.
And these documents are subsequent documents, Milord. So those
No,
cannot be, yes, Milord.
No, subsequent documents, is it related to the acquisition of the property?
There some
There is the
other order, Milord, some other order passed in LAC.
Then
So which was
is it,
passed in 2017. This appeal was filed in 2012. So how that 2017? Because Milord, this rule,
madam, relevance
Yes, yes.
is whether notification for acquisition of the land which they have produced additional documents is the same year. Is it related to the same land or adjacent land?
No, Milord. And even otherwise, Milord, my response submission, like that, I'm relying upon Milord order this 27 rule, order 41 rule 27, which says that party seeking to produce additional evidence establishes that notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not after the exercise of due diligence be produced by him at the time of. So
Yes.
which document was not in existence at that time, he could not have produced even after due
So
diligence.
that section 18 is not applicable to that your case.
Milord, it was
No,
filed
28.
under
Section 28A.
Milord,
Section 28A is
Milord,
applicable or not?
Milord, that they have not, I mean, I have to examine whether 28 will be applicable here. But
28A is
he has
applicable,
not-
then it is not that.
Milord, he has not submitted that. Milord, it is totally different village also, Milord. It's not same village.
No,
And
no,
he has not relied
no,
upon.
that's
Yes,
what
Milord.
that I am asking. Section 28A can be applicable only in the case of very same notification.
Notification.
If
Yes, Milord.
subsequently, in respect of that other properties, it is enhanced, he is entitled for seeking for a reference. You have to, yes.
Milord, but he has already, Milord, see, that happens when he has not applied for reference. Here, Milord, he has already, Milord, availed the remedy. He has filed section 18 application and he has got the award. He has got enhancement to
No, that-
75, 45.
No, that is
No,
immaterial.
that is
Now,
applicable when he has
whether,
not
no,
availed
whether
remedy,
this
Milord.
is, no, whether it is related to the same property or not, or same notification. 28A, even 28A, or if he wants to rely on that, it should be related to that same notification and
Yes,
same.
yes, Milord.
Is it same this thing property?
Milord, I'm not sure, but mostly it is not, Milord.
Now,
Mostly it is not.
where is your counterpart, madam?
Milord,
Pass on, or we will have it next week.
next week, Milord, maybe.
Yes, none appear for the appellant. Leave this matter next week.
I will satisfy, Milord. I will just examine this
Yes,
point.
yes,
I will examine this point.
Yes.
28 appeals in terms of appellant, appeal 18.
Yes, what is this? Part 3, class 1, for amputation through shoulder joint, 7,20,000. Yes, in terms of that, it has been awarded. This appeal is filed under section 23(1) of Railways Crime Tribunal Act 1987 by the applicant challenging the judgment and degree dated 21/3/2018 passed by Railway Crime Tribunal in claim application number OA 2 nado N2U 156. In claim application number 156 of 2017, whereby Railway Claim Tribunal has awarded a compensation of rupees 7,20,000 with interest. Three facts of the case are that applicant was working as a coolie. Applicant has aged about 36 years, working as a coolie, has presented the application under 16 of Railway Claim Tribunal Act 1987, read with section 123, 124A and 125 of Railways Act, seeking a compensation of rupees 8 lakhs. You have sought for an 8 lakhs. Your claim itself is an 8 lakhs from the respondent railway as compensation for injuries sustained by him in an alleged untoward incident. On 30/11/2016, in the night, the claimant has suffered an injury while boarding the Hubli-Bangalore passenger train at Harihara railway station or going to Kodaganur village. He fell down by losing the control of his balance since the train started moving all of a sudden. His right hand came under the running train and amputated up to the right shoulder, sustained injuries all over the body. Hence, he has filed a claim petition before the Railway Claims Tribunal. On service of summons, the respondent has appeared through their counsel and filed a written statement. On the basis of the pleadings of the parties and the evidence available on record, the Railway Tribunal has granted a compensation of rupees 7,20,000, being agreed by the same. The applicant has filed this appeal. So and so learned counsel appearing for applicant has contended that the compensation awarded by the tribunal, 7,20,000 towards injury, pain and suffering by the claimants is on lawyer side. The finding of the tribunal towards loss of income on account of permanent disability, though appellant has suffered grievous injury, is error. Is contrary to the material available on record. Hence, he sought for enhancement of compensation. For contra, so and so learned counsel appearing for the respondent has contended that as per the schedule under Railway Accident Untoward Incident Compensation Rules 1990, the injuries suffered by the claimants are referred to Part 3(1), the amputation through shoulder joint. The compensation fixed under the schedule is 7,20,000. Accordingly, the compensation has been awarded. There is no error in judgment and award passed by the tribunal. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Perot's judgment and original records. It is not in dispute. The applicant has suffered an injury on 30th 11 2016 when he was boarding the rail. When he was boarding the train at Kodaganur railway station. As per that evidence of the parties and material available on record, the injury sustained is amputation of right hand from the shoulder. As per that Part 3.1 schedule of compensation payable death and injury under the railway accident and untoward incident, bracketally, compensation rules 1990. The compensation has been fixed as 7,20,000. Pursuant to that, the tribunal has granted a compensation of rupees 7,20,000 with interest. There is no error in judgment and award passed by the tribunal. Yes.
MS Nagaraja for appellant. So,
Yes.
the appeal is also pending.
Yes.
Like this one, I see the instruction that the appeal is to be continue or not.
Yes, madam. What is your request?
Because the matter is going on.
No, you want to withdraw that. If you want to withdraw that, what is that? You want to withdraw next week, I will fix the date. Yes. At the request of counsel for the appellant, reach this matter on Thursday next week. Along with so and so. Yes, yes. Yes, you verify it. Yes.
Number 30, Vivekananda yes for appellant, SP Tulkar. Yes, Sampath.
Yes. Yes, learned counsel for the appellant has filed a memo dated 5/1/2023 seeking leave of this court to withdraw this appeal. Memo dated 5/1/2023 is taken on record. The above appeal is dismissed as withdrawn.
Number 31, Arjun. Serial number 32, Yama Redemoted for appellant, is Kumar.
Yes. Ready? Huh? You want time? No, you want time? Yes. At the request of counsel for respondent, reach this matter next week.
Number 33, Shilpa Shah for appellant.
Yes, madam.
Serial number 33, Shilpa Shah. Serial
Yes,
number
Milord.
33,
Similar
Yes,
matter.
yes, Milord. Yes,
These
yes,
are all
Milord.
similar matter.
Yes, similar matters, Milord.
Now, why have you not brought to the notice of that court regarding that proposition of law? Unnecessary, these are all the appeals. You have not brought to the notice of that court regarding that proposition of law.
Milord, it was brought to the notice of the court, Milord. But still court passed order, and Milord, if your lordship look at it, court said dismissed. And after dismissal, they said that I am granting this.
Where is that?
So there are several judgments that once set aside, then that judge becomes functus officio and can't do anything else. So here,
Oh, that is secondary. Then which is the judgment you said that in respect of that arbitral award?
cannot be modified.
Yes, they cannot
Yes,
be
sir.
modified or enhanced. Which
Yes,
is the
Milord, there
judgment?
are, Milord, two judgments which we rely upon are of our own High Court.
Yes.
And now, my lord, recent this Justice Nariman's judgment, where
Yes.
Honorable Supreme Court has held that even it amounts, if order is modified, it amounts to crossing Lakshman Rekha. That is what judgment passed by this.
Yes.
My lord,
Admit.
my lord, in other
Stay.
matter, next time when it
Stay.
comes, I will come before this honorable court and produce those judgments. my lord.
Yes. Stay as prayed for. Same. 35 same.
Number 36, Rakesh B. Bhatt for appellant, Sri H. Giri Rao.
Yes.
Oblige.
Property is vacant, sir.
Yes.
I have put up a board. But your factor was taken with you. Try and go to dispose of this matter.
Hmm.
But before vacation.
Now that what is the suit for?
Intention to dispose of.
Yes, yes. Wait. Just I need little facts. Yes. Suit. Yes. Yes. Now that yes. Hmm. Now your application under order 39, 2 and 3. It is rejected. Plaintiff appeal before this one. Yes. They have failed to prove their possession. Therefore, now that what is that your
Don't sell it. Dispose of. Don't sell it. I tell some board I will put there. Case is that. Take it back.
I can pass that. Yes. Now, what is the stage in the suit? But yes. Yes. That this appeal is posted for orders at the consent of the parties. Yes. Matter is posted for admission, consent of parties and hearing and disposing of. That's all. Yes. This appeal is filed by the plaintiff under Order 43, Rule 1 or of CPC, challenging the order passed by first additional 17th additional city civil judge and session judge, Bangalore, on IA 2 and 3 in OS number 3142 of 2022 on 20th July 2022, whereby application filed by the plaintiff has been rejected. Plaintiff has filed a suit for bare injunction before 17th additional city civil and session judge, Bangalore, in OS number 3142 of 2022. He has also filed an application for application 2 and 3 under Order 39, Rule 2 and 3. Both has been dismissed. Now that his challenge is only IA2. Oh, both, because granting also. Yes. Yes, sir. Yes. IA, he has filed an. Yes. Yes, I understand. Yes. He has filed an IA number 2 under order 39 2 and 3. 39 1 and 2. Yes. The same is rejected. And IA number 3 filed by the defendant has been allowed. Yes, allowed. The trial court, after considering that arguments of both the parties, has passed an order. The matter in dispute, the site in dispute is a vacant site. Two sites in disputes are in the vacant sites. In the interest of justice, I am of the opinion that the order passed by the trial court can be modified to the effect that the parties are directed not to put up any construction in the suit scheduled property till the disposal of the suit. The plaintiff is also directed to remove any board is there. The board put up on that vacant site within 24 hours from today. Not to put up any constructions or not to alienate that property till disposal of the suit.
Both the parties not.
That's what I said. Both the parties are directed not to put up any construction, not to alienate. Since it is a vacant site for the interest of justice. That's what I said. Yes. The trial court is directed to dispose of the appeal on or before summer vacation. With that observation, the appeal is disposed 2023. Otherwise, that summer vacation is there. All pending up. That's what I said. Yes.
Number 37, attorney for appellant, Vipin Hegde.
Yes. Now that its suit is dismissed. Then they are also beneficiary of this dismissal. Should they not be heard?
I think I did notice. They are given no objection in the trial court.
No, that is different. Tomorrow, technically, they cannot take that. If they are in your favor, then I think he is also no objection for restoration for allowing that appeal. Why can't you serve the counsel appearing there and take that matter?
Order notice on.
Yes.
And also.
Yes. Where is that order for this thing? Yes. One memo code, Mr. Instructing Counsel, learned counsel for. Yes, filed a memo seeking recalling of that order dated 8/8/2022 only in respect of dispensation of notice to respondent number 1 to 9 and 11. Accordingly, dispensation of notice in respect of so to respondent is recalled. Issue notice. The appellant is directed to pay the process issue notice to respondent number 1 to 9 and 11 In addition, the appellant is permitted to serve appeal memo to the counsel who is appearing for respondent number 1 to 9 and 11 before this 1 to 11, 1 to 9 and 11 before the trial court. Yes. You want any specific date because he is also no objection, it can be disposed of. Yeah, yes, emergent notice.
Number 38, Supreme.
You can move that. Yes.
Appellant A. Sampath.
Yes. Now that is it an ex parte interim order has been granted? No. Here interim order has been granted.
They have already filed but they did not appear on the day.
The emergent notice appellant to pay the process within 13 days. Registered dispense IA already on record pending consideration of IA. There shall be an interim order of injunction till next date. Till next date of hearing. It is not an absolute interim order. Interim order. Yes. What is that urgency? Now that you are so threat of that, why you are not present when that matter has been heard on that day? No, what is the suit for? We'll see that if there is any immediate threat. Otherwise, I will grant a time. Let me first. Now, this is plaintiff appeal. Who has filed that appeal? Plaintiff's appeal. Suit for? Wait. Let me just give that brief facts. What is the order you have challenged? Passed on IA number 1, filed under Order 39, Rule 1 and 2. Yes, seeking a grant order temporary injunction restraining the defendant there. Yes, your injunction is rejected. Yes. Suit for permanent injunction. Injunction application is rejected. On what ground, mister? You have failed to prove your position. What is that interim order passed by this court? What is that injunction has been granted?
Property was leased out to one Siddhartha who had established the office in the Sampath Enterprises to the physical property, and the same would indicate the person of the property by defendant. Defendants are claiming that they have leased out this property to Sampath Enterprises. They are not producing the lease document. Sampath Enterprises, they have produced some GST certificate. The GST certificate itself shows that this is not elsewhere. Out of that should be wrong. Such circumstances, the Honorable Court came to the resolution.
What is that interim order? No, that admittedly you are not in the position.
No, I am very much in the position of the property. I am very much in the position of the property.
No, that they have leased out that into that Sampath.
It is their contention. The written statement they are making the contention that they have leased out the property. They are not in the position of the property. The vendor is in the position of the property. They produce one GST certificate. That GST certificate states the addressing of the Mediation.
Then I will modify it and say that status quo in respect of the property. If you are in that position, you will continue. Or Sampath Enterprises is in the position, they will continue. Or that defendant is there in that position, they will continue. Then it shows that you are not in the position. Now, then I will protect your position if you are there.
In order to stay today,
No, the problem is suit for injunction. If you are not there in that position, then you can take these advantages and disturb him. Yes. 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 Page 28, 23. What is that? This thing? Property is an commercial complex. House property, residential house. Is it case that he is residing in that suitable property? Yes. Paragraph 4. No, that page 23 is something different. Application. No, that is what that. 28. It is a deed. Some deed it is there. 23, that is a stamp paper. Client. Appeal paper. Yes, I have seen that additional documents. 28. Yes. Yes. Yes.
I also admit that there is further, then document number 6. Accordingly, all the revenue records are located in this name, and further, they nothing are applying for conversion from agriculture to non-agricultural purposes, right? So on so issued by the from the Bangalore. The copies of the order and conversion are produced. Then the plaintiffs of rights that after conversion, development of the land is subject to the option of creating development. Nothing of the actually located conversion. To purchase the 1975, develop the land, then according to them, you guys make.
Who is Nazir Saab?
Survey number 22 Baba. What happens to us is that this Nazir Saab, he develops a layout there, he forms a residential layout, sells those sites formed in this survey number 22 Baba.
Now that who is the plaintiff then? What is the relationship between the plaintiff? Yes.
Page 30.
Yes.
They have given the name of so many people. That's what they Evidence of Nazir Saab.
Yes.
Releases the entire property in 4 hours. And will shake the by a registered deed of release dated 29/12/2021. Kindly note that Nazir Saab by the children, according to the plaintiff, executes a release deed on 29/12/2021. Now, Dusty says this property paragraph 6. Plaintiff submit that the Dusty check is sold in property to in favor of Rose Pasha, that is plaintiff is a registered document 6/6.
The figure is sold after 21.
execute release. I think it may not say it's stated in 20.
When you have purchased,
So that is why I said,
you want to defeat that interest of the persons you are doing it.
I can take mine or not. Then it's only one piece of document that shows.
Now that we'll come to that reasoning of the trial court.
I need to take page number 12 of the document, which is say, really take a page number 12. Page number 12. That is dated 16 September 2004.
Page number, no, page number 12 of what?
It is a, along with that compilation of documents.
That you have to say.
That's what is used.
Yes.
That is the annexure R1, which is produced the same date. He says, Nazim of children's executed DPA in favor of builder purchasing his vendor. He has not produced a document to show that whether there was a DPA or not. He just request to kindly take.
There is a sale deed, is it not? Have you filed any declaration?
There was no title passed on. How can he claim? There is no DPA produced.
No, Mr. That is all different. There is a registered sale deed. If the title is disputed in the injunction suit, remedy is to file for a declaration.
True, my lord. True. That is the reason I need to say, I will convert my suit into a declaration suit. Prima facie, my lords, only one important document to say, subsequently being the legal heirs of the demise of persons and joint owners of.
Now, Mr. Counsel, I cannot decide that legalities of the, once it is in a register, title has been transferred. You are disputing that, then you have to. Yes.
Parties to maintain status quo that will be taken care of for either of us. If he is in the position, his interest is protected. If I am in the position, my interest will be protected.
Yes. That's all. I will pass the status quo order till next year. No, Mister. You have made his submission. Don't dictate the court what the order has to be passed. It is my order. If you are agreed, you challenge it. Don't dictate it. Then you can make your submission. You have made your submission. I heard it. No, that's what that I am granting a status quo. Then you are scared. It shows that you are not in the position. Yes. 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 We are not concerned with all these things. Matter will be pending before this. No, Mr. Counsel. Matter is pending before this court. We are granting that status quo. In the meantime, if you are in the position, if they are trying to interfere, you can move that application any time. That shows that they are trying to interfere. It shows you are not in the position. Yes, I heard you. Yes. No, therefore, I am protecting your interest by modifying status quo. Yes. This court, by order dated 28/11/2022, has passed an order pending consideration of IA 1 of 2022. Ad interim order of injunction has been granted. The respondent has filed, as the case number, serial number, has filed IA 2 of 2022 for vacating that interim order. Learned counsel for the respondent has submitted that. First respondent has submitted that they have purchased this property from, what is that? They have purchased the property by registered sale deed dated 16th of September 2004. The claimant, the plaintiff are claiming that rights on the basis of the sale deed dated 6/6/2022. Their sale deed is after the sale deed is later one. Since the defendants are in the possession of the property by interim order passed by this court, they are trying to interfere into the possession of the property. In view of that above dispute, I am of the opinion consideration of this court that order dated 28/11/2022 has to be modified, and both the parties are directed to be maintained status quo in respect of suit scheduled property till next date of hearing. If there is anything, if they are trying to dispose of sue after this, you can move at any time. You give the police complaint, then you. Yes.
39, CM Nagabhushan for appellant, M. Ramaswamy, University Nayak, P. Shankara,
30. 39. Yes. Yes, Mr. What is this? Yes. No, today it is posted for vacating. Although IFR stay. Yes. Now, what is that interim order granted earlier, Mr. Now that suit for plaintiff appellant, suit for partition. Now, what is the defense of that defendant, Mr. You are he is a purchaser. Now, who has alienated? Which defendant has alienated the property? 1 to 3 has alienated. Yes. In favor of respondent number 5. No, is that defendant number 1 to 3 has filed any written statement? Have they contended that it is joint family properties or self-acquired property? It is under dispute. Now, Mr. Senior Counsel, now that is the dispute. Yes. Well, 10.
Then Lord, on 18/1/2016, 18/1/2016.
Hmm.
Responded by 2 and 3. And these their right, relinquish their right. So they will a child give. Therefore, they relinquish their right in their first respondent. That is 18/1/2016.
Hmm.
Then after the release, the revenue record was changed in the name of the first respondent. That's why we brought the land converted. This was the very on 18/11/2020.
Now the relevancy is gift deed. I will challenge that. No, no, that is the push. Hmm.
And then on 18/11/2020, this first respondent got his land converted to residential.
No, that is.
Elaborate procedure provided for conversion of the land. You go to the for all the things that was converted. Then the reason why you want the this is about 4 acres. 8 more acres towards the farmer level. Because of lack of then we ask them, get the release from them on. And these two sisters have gone to the registrar. We know they are of their brother. That is the first respondent.
Including plaintiff.
Yes.
When
I'm not concerned about other property.
yes.
This 4/2022. This the first respondent along with his family members executed sales in my favor. I have paid substantial consideration to purchase property.
No, 8/4/2022. After taking that release deed, they have.
Yes, I have purchased. Then they filed all the dependents of private people. They said, yes, this is the property of the other. They accepted all this information. They said, then when the sister were gone, with the plaintiff, then the fourth respondent, she joined the sister.
Where is the property? Now, when they have given a release deed, brothers has not paid anything to that sister.
We have paid one brother, they have paid 5 lakhs. 10 lakhs each they have paid. And one sister is encash. Another sister, it appears that some children they have there will be something because the property is children's property. She has not encashed check. And in the written statement, the sister who has joined with her another sister, they have jointly executed the release deed. Both of them jointly executed the release deed. Statement and written statement and an affidavit before the trial court, stating that they are knowing that this property is not that going to given that they have under the service property, they are really to right. And the trial court taking into consideration of one, have a case as a not very and even the first father is the government not being challenged. these two arguments are not being happening.
No, the prima facie case is that you have given a release deed in respect of that. Wait. Wait, yes.
So this is the situation. Unless this situation that is not either not pending or when one of them is developed because of the engagement. And then the responsibility, you must ask for declaration. One that is one that. Then you go otherwise, like property one of this value, it is value not be shared with right. Share they got executed. Some other property. There's no way to get against
No, that the relief is that not to alienate or not. Oh, what you are developing that property?
Equal extent of the land is available only which available just available. Ultimately, this succeed. The properties they are in nature are not vacated, they are not challenging the partner. And apart from this, some other properties are available. Therefore, the taking into consideration of the investment, they have they are not challenging my unity. Therefore, injunction order, section order 99 good for us alone. What my management said as
No, that only, wait, I will come. Only your grievance is that now that by interim order you want to alienate that property that has been, you want to alienate that property. No, I'm not disputing all that things. See, now that you are a developer, now the problem is, yes, some extent you have made out on your case, you are right. The problem is that if you create a third party interest, you want to develop, you develop, but don't create that third party interest. No, therefore we will fix that. Otherwise, no, we don't know who will succeed. Then again, that persons, it has been transferred to that other's hand, then that problem will arise. No, that is true. See, even in that final degree proceedings, this can be objected to that your vendors and all. That can be done it. Now that we can direct the trial court to dispose of within that time, you can go ahead with that all other development except alienating that. Now, what is the stage of your development? No, I don't know you are developer or not. By seeing that cast title, I thought that developer. No, that. No, we will direct the trial court to dispose of day-to-day the proceedings. If that both has to be cooperated. No, that's what, see, you take that plan, you want to, develop demarcation, everything you can do it, except alienation, because third party is interest to granting that, because prima facie they have given a release deed in your favor. That now that the interest of the court is that it should not be create third party. They should not be tomorrow. Suppose if we don't know what will happen to the show, persons who has purchased if something is, they have landed in the litigation, you know that you are a builder, persons who has, stored all this money and, within this thing. No, that is true. Misspendence is true. I am seeing that interest of that purchaser, because the person who has hard-earned money has been invested for buying a money. That is the only interest. I am not interested in respect of you both. Yes, you both are landlords and having a sufficient this thing. That is, no, that is true, Mr.
Not the entire injection. Only never come for 4 acres. That is where there are the lot of properties are available. Therefore, the injunction will be done to the client. When it's available, that is subject to let them not.
No, therefore, injunction restraining you to develop or other things, it's different. Not to alienate, I think we can protect you the development alla nimige injunction kottidre, then it will affect your right because you invested and all. You do all other proceedings, but not to alienate, because no, that now what is the stage now? You are I will refer to that mediation. Then yes, and then protect 1/6 share of that. ಅಲ್ಲಲ್ಲ ನೀವು 1/6 ಶೇರ್ ಅಂತ ಅಂದ್ರೆ ಎಲ್ಲಿ ಅಂತ ಬಿಡ್ತೀರ ಅವಾಗ? ನೋ, ಅದಕ್ಕೋಸ್ಕರ ಹೇಳಿದ್ದು ನೀವು ಡೆವಲಪ್ ಮಾಡಿ, ನಾಳೆ ಅವ್ರು ಸಕ್ಸೀಡ್ ಆದ್ರೆ ಡೆವಲಪ್ಮೆಂಟ್ ಪೂರ್ತಿ ಸಿಗುತ್ತೆ. ನೀವು ಮಾರ್ಬಿಟ್ರೆ ಅಂತ ಅಲ್ಲಲ್ಲ, ಐ ಅಂಡರ್ಸ್ಟೂಡ್. ನೀವು ಎಲ್ಲಿ 1/6 ಶೇರ್ ಬಿಟ್ಟು
that we give an entity. Third condition of this book are because of this book not given. And therefore the report there is a not 6 it is we are ready.
Oh, you see, yes.
If they succeed, let them withdraw. Provided
No, that is not the fair. The leaving that 1/6 share is that I think best this thing instead of that. That's what that I understood, that why you are making such a suggestion. Property has to be developed as per that whole. No, that now that the problem is, why can't you refer for the mediation for a settlement? If it is among that family, if it is settled, then after settlement, if they are agreed to leave it to entire extent, you can do it. You'll refer to that mediation. You try once. Mediation al nodi our sisters. You also, Mr. Convince your sister. If you know that whether you have paid the money or not. See, ultimately result is also you have to be convinced. If both of them, you also convinced. No. See, ultimately, Nagbhushan, most of the time, it's this thing. Then builders without that intimation and all. But in this case, you have given a release date. That is how that where I have struck that. Whatever may be the purpose, you have saying that registered. Then you have not sought for a declaration of sale deed on that ground. I will refer to that mediation next week itself. Please. Yes. Yes. When do you want? Ido family partition settle ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಆಯ್ತು ನನಗೆ ಇವರೇನಾದ್ರು ಅಗ್ರಿ ಮಾಡ್ಬಿಟ್ಟು ಇನ್ನೊಂದು scheduled properties they are ready to give it, she may be given up, then entire suit will be disposed of. That is that is ಅದಕ್ಕೋಸ್ಕರನೇ ಮೀಡಿಯೇಟರ್ ಕೂತ್ಕೊಂಡು ಕೇಳ್ತಾರೆ. If it is possible, otherwise we'll come back and we'll see that. Yes, we'll fix that within 2 weeks. It has to be settled. Yes. After heard the learned counsel for the parties, this court is of the opinion that matter can be referred to that mediation. Matter can be settled through mediation. Therefore, the matter is referred to that Bangalore Mediation Center. Bangalore Mediation Center. The parties are yavattu any date. Alla nimi convenient. ನೀವು ಯಾವಾಗ ಬರಕಾಗುತ್ತೆ ಇಬ್ಬರಿಗೂ ಹೇಳ್ಬಿಡಿ. ಫಸ್ಟ್ ಬೇಡ, ಲೇಟ್ ಆಗುತ್ತೆ. ಯಾಕೆ ಅಲ್ಲ 17th 18th ಅಲ್ಲ ಆಗಲ್ವಾ? Working days ಅಲ್ಲಿ yes. Parties are directed to be present before that mediator in Bangalore Mediation Center on 18th. Office is directed to transmit the file to that Bangalore Mediation Center. Let us see. Interim order granted earlier is extended till next date of hearing.
HB Devaraju.
Post this matter, data ಕೊಟ್ಬಿಡ್ತೀನಿ ಅವತ್ತು. Post this matter on 23rd. Yes.
Party PK Rajagopala.
Mr. Page.
Serial number 40, sir.
40. Yes, Mr. Learned counsel for respondent and appear for the appellant. Learned counsel for the reference space 2 weeks time to file an objection. Objection to IA 1 of 2022. Yes. Call this matter after 10. I praise weeks time to file an objection to IA 1 of 2022. Call this matter after 10 days.
For appellant.
What is that connected message? Office is directed to delete the name of Sanjay Ji, shown the name of person as a counsel for the notice. Direct to matter status property till next date of hearing. Same this thing. What is that memo for reporting the death of the sole respondent? Who is appearing for that this thing? Then you have to file an at least application for bringing LRs. Once they have reported, limitation is started. Yes. Or ಇದರಲ್ಲೂ ಏನು ಆಗಿದೆಯಲ್ಲ, ಡಿಲೀಷನ್ ಆಗಿದೆಯಲ್ಲ. ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿದಾರಲ್ಲ, ಸುದರ್ಶನ್. ಆಫೀಸ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಡಿಲೀಟ್ ದ ನೇಮ್ ಆಫ್ Sanjay G for appellant. The parties are directed to maintain status quo in respect of suit scheduled property till next date of hearing. Yes, in the meantime. Who? No, you have to file an application. They have to bring on record, then they can be taken a notice, mister. Otherwise, they are not the parties here. At least you have to file. Alre, avrige to take notice in respect of the LRs, they are not a party. How can they direct, mister? First, you have to file and then they have to come on record. Then he may be directed to take notice because he has filed an wakalat. As not today, they are not a party here. Yes. Now, what is that order now you have passed? Yes.
Number 42, Parameswarappa CT for appellant.
Yes. Yes. Partition suit. Yes, heard, admit.
43 adjourned, final disposal matter, serial number 44 adjourned, final hearing matter, serial number 45.
Now, Mr. Counsel, heard, admit. Call for records. The net counsel for appellant is directed to file in a paper book within 8 weeks. Yeah.
Serial number 45, M. Sudhakar 5 for appellant, G. Balakrishna Shastri.
Yes, Mr. Fine. Yes. Now, who has filed that appeal? Defendant. Defendant number 5's appeal.
Yes.
Suit for
Partition in separate position. Kindly produce the plate.
yes,
There number I, defendant number 5.
yes.
I am not familiar.
That who are you?
I am not familiar. But your worship, kindly refer to the schedule of the plate.
Yes,
That is about 29 cents.
yes,
In page 28 down.
yes,
Out of that property of mortgage to the community. It is unto so as well as renting.
yes,
Mortgage statement of India.
yes,
For a family necessity. And was termed as the NPA. Just are taken under section 13. But defendant number 4 in the suit,
Hmm.
or maybe 3,
Hmm.
it's not 9.
Hmm.
How will the guardian of legal treaty
Hmm.
had challenged that proceedings? Still, section 13
Hmm.
for the Interim Tribunal, DRT.
Hmm.
That appeal, DRT has restricted application. Only that there was no irregularity in proceeding.
yes.
Thereafter, the sale was conducted in 2008.
You have purchased through that public action.
2009, our public auction was conducted. January 2009.
Yes,
And license of property in 29.2.
yes,
I have purchased for a consideration 15 lakh 1,000.
yes,
And sale certificate was issued by law on 13/4/2009 by the bank. I was put in possession. In page 53, we can give the list.
yes, yes,
This sale certificate was called in question by the defendant number 3.
Hmm.
Before this order will go. In page 61, you watch the can see the order of the defendant.
yes,
This order is dated 24 January 2011. Issuance of sale certificate. At that stage, application before the DRT came to be rejected, and he had filed an appeal before the debt recovery appellate authority.
Yes.
Now that appeal is also came to be dismissed. So what should I kindly turn to the Lord? 365. Since the sale contract in the case has taken place, the conditions of the appeal before the appellate authority. The conditions regarding the illegal is committed in the course of the said sale, and also the argument before the appellate tribunal. Either is subsequently the or all is not the reputation is dismissed.
Yes.
Thereafter, the appeal before the DRA is also dismissed. All these questions.
Yes.
Now, my lord, has engineered this suit to his minor son. So, what should I kindly turn to the forum of petitioner in page 61 is vision of mind.
Yes.
Suddenly, his minor son.
Yes.
Common line.
Now that suit has been filed for partition.
Suit has been filed for partition. There also they contend that this particular in the suit also. In page 25 it may be solution. Item is also included, and I am married as a dependent. And injunction is not valid. So only in respect to this property I will file a claim.
Yes. What is that order passed by that trial court?
Page 21. Item number 2 filed by the plaintiff under order 31. The defendant responded that means all persons claiming in the film are restrained by means of temporary injunction. Get in charge of alienating specific property in the disposal of the suit.
Yes.
There is a restraint order against me also.
Not to alienate.
In charge. And the zero to the and there is a bar under the act.
Yes.
Even for the civil kindly turn to the law contained in section 34.
No, you have benefit of any interim order before this court.
Sort of state in the disposal.
Then it will be continued till disposal of the suit. You have see from last 11 years he is enjoying that interim order.
And valuation. Share learns he has calculated 3 lakh certified company.
So that office has not raised any objection.
Page 27, para 6.
Yes. Yes.
Value for purpose of jurisdiction. Section 52. It is 10,39,922. For the court is so it's at 3,75,000. So here comes section 50 value. What for the court fee?
No, now that 10 lakhs has been enhanced to 50 lakhs by amendment. I think they are
10 lakhs more than 10 lakhs.
I think after filing this, I think there is a modification. Now that it is not a 10 lakhs. Alva. Illa ade idya. Ade ide. Yes. Other 15 lakhs illa. Namda internal is. Yes. Now that by valuation you are. Yes.
Variation for the purpose of this share is 22.
Yes.
That is value jurisdiction for the purpose of payment.
Yes.
And the jurisdiction will be the same.
Yes. What is-
Valuation.
Yes.
Valuation.
Same.
Whenever we find it. So, always inserts, says, what is your step? Ask. The whole entire property may be more. That's also. Valuation of the value share is the determinative factor in the jurisdiction of the court. So the factor consequently by the king of the sovereign. That is so large. The valuation of 39,922.
Why you have not filed any vacating and urging this for last 10, 11 years?
There is no question of my share. I am not a co-share again. I am not.
Jurisdiction always depend on the rate or share.
I think some judgment ಇಲ್ಲಿ ನಿಮಗೆ ಕೋರ್ಟ್ ಫೀ ಕಡಿಮೆ ಇದೆ. ಕೋರ್ಟ್ ಫೀ ಜಾಸ್ತಿ ಇದ್ದಾಗ ಏನ್ ಕ್ಲೈಮ್ ಮಾಡ್ತಾರೆ ಗೊತ್ತಾ? ನೋ ಮೈ ಶೇರ್ ಇಸ್ ದಿಸ್ ಮಚ್ ಓನ್ಲಿ ದೇರ್ಫೋರ್ ಐ ಆಮ್ when we have raised that why you are not paying that so much, then they are saying that no my share is only this much. I think same law is applicable. There is a judgment on that point. Whether that he has to pay that court fee for entire extent or that only that the rights he has the property. No, ultimately, again, if you go to the district court, he has a benefit of interim order from last 11 years. There also automatically he will get it. Then matter will be struck there. Again, district court then it is a fresh case for them. They can wait for another 5 years. Then interim order, when High Court has granted, definitely they will grant. Not only granted, it was there for last 11 years. Because without going all these things, I can say that since interim order is there, trial court may be directed to dispose of. No, I mean, either way, I am not asking you. Have you put up that construction after taking that? No, I will say parties are directed to be maintained status quo as on today till the disposal of the suit. Because have you taken that benefit of that interim order has made any development or this thing that can be protected? That's no, Mr. Absolutely, in respect of your lifetime claim. No, that is true. You are all that has to be this. No, that is why when that interim order is there for 11 years, he has not sought for any vacating. Taking that benefit, you have not sold. Therefore, via media, I can say that maintain status quo as on today till the disposal and directed to dispose within 6 months. If you have sold it, that is also protected because status quo as on today. Why that? 11 years, you have not made any mind to sell. Then wait for another 6 months. No, I will restrict only that property. Others, they are not before this court. No, see, this is the order I am not making on merit. There I have to see I'm saying that since order is operating for 11 years, on the other hand, what that senior counsel is submitting that, see, you have not utilized that interim order. Why can't you wait for another 6 months? Suppose if he has utilized and sold it, that is also protected because there is an interim order. Say that, yes. Instead of that going for a merit, whether it is maintainable or not, I will just on that point, yes. This appeal is filed by the defendant under Order 43, Rule 1R of CPC. I will clarify that. Yes.
The properties are there. I mean,
Yes, yes, yes. Challenging order dated 2nd November 2011, passed by Senior Civil Judge JMFC Bantwala in OS number 2 of 2010 on IA 2 filed under Order 39, Rule 1 and 2. For the convenience, parties are referred to their ranking as per trial court. Plaintiff has filed a suit for partition and separate possession before Senior Civil Judge JMFC Bantwala in OS number 2 of 2010. He has also filed IA number 2 under Order 39, Rule 1 and 2 with Section 151 of CPC, seeking a temporary injunction against the respondent, restraining them, their men, servant, agent from any way meddling with the plain B scheduled properties. This is only plain B scheduled properties. Adrallu nimdu Adral third item. Yes. Yes. By alienating or creating the charge or altering the status quo pending disposal of the suit. The application has been allowed by order dated 2nd November 2011. Yeah, enter other. Yes. That I will just. Being agreed by the same. Respondent number, defendant number 5, who is claims to be purchase item number 3 in B scheduled properties through public action, has challenged the order dated 2nd November 2011 before this court. This court, by order dated 4/1/2012, granted a stay of impugn order only in respect of 50 cents in survey number 29-2 of Yen village or Puri village. Sajipa Mudnur village. Pane Mangalore antide adke kelidde. Pane Mangalore village. That interim order was granted by the court has been. Ala interim order latara ide. Pane Mangalore village anta. Yavadada? Interim order granted for Pane Mangalore village. That interim order has been continued time to time and it has been made absolute. This has been, the interim order is there from last 11 years. under the circumstances, in the interest of justice, the order passed by the trial court on IN number 2 is modified to that effect that the plaintiff and defendant number 5 is directed to maintain status quo in respect of 50 cents in survey number 29/2 situated. Correct, Ada? Yes, Pane, Mangalore village. For a till disposal of as on today, status quo as on today has to be maintained till disposal of the suit. With that observation, the appeal is disposed of. If you are sold as on today, that will be protected because you might not having any instruction. One of the sudden ಯಾವ್ದೋ ಹಳೆ ಮ್ಯಾಟರ್ ಪೋಸ್ಟ್ ಆದ ತಕ್ಷಣ ಪಾರ್ಟಿಗಳಲ್ಲಿ ಏನ್ ಮಾಡಿರ್ತಾರೆ ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತಿರೋದಿಲ್ಲ. Yes. Yes. Yes.
Number 5.
It's an agricultural property situated in the city of the agglomeration.
So court fee.
I'll decide on the party. Last week I said like.
That is not. Anyhow, you have made in a law has to be settled. ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಮಾಡಿ ಸಕ್ಸೀಡ್ ಆಗಿವಿ ಅಂತ ಲೆಟರ್ ಬರ್ದಿದ್ದೀರಾ ಫೀಸಿಗೆ, ಅವನ್ ನಾವು ಮುಂಚೆನೆ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ ಲಾಯರ್. Yes. Yes, Mr. Yes. Yes. Now this trial court appellant, you are a plaintiff appeal. Defendant appeal. Yes, Mr. Selskit, now you want some time. Yes. When do you want? 10 days. Yes, Mr. Selskit, you want? Yes.
Certain date will be granted.
Yes.
So that no further date should be granted. This
Yes.
cancer patient, he is going on for the past 2 years.
No, that one should be happy that patient is still there. That is he wants to take an instruction from the same party. That means to say that.
He is not taking any instruction from the client. He cannot report the client also. It's forbidden.
No, not him. We are saying that instructing counsel. He cannot be seeking this thing. He is seeking in a time on the instruction counsel. Yes.
Date fix money. I will argue the client.
Yes. What is the date you want? 21st. Huh? Yes. It is this matter on 18th. Yes. That is not a ground. Now that we can argue even if you are there in that abroad through VC. What is the case, madam? Suit for? Yes, this is defendant appeal. Suit for? Yes, where is that plaintiff? Or 7 rule 1. Prior pass an order permanent injunction restraining the defendant anybody claiming through them from so and so. Suit for injunction. By appellate court. Where is that order? Interlocutory application filed under order 39(1 and 2) of CPC is allowed. No, that injunction has been granted. The correct file entry. Yes, yes. Injunction has been granted. What is that injunction they have sought? Grant an interim order, temporary injunction against the defendant, their men, or against to restrain them from interfering with the construction of the suit scheduled property and scheduled suit. Yes. Construction according to the- Then what is the order passed by this court? Is there any interim order in your favor? Where is that? Net counsel for the appellant has filed a memo enclosing the paper publication for use of net counsel for the appellant filed and seeking issue of notice. When that interim order, emergency notice, take 9 summons to maintain status quo for 4 weeks. Interim order extended. Interim order is extended. Other orders. Yes, you are enjoying that interim order as on today. Who is appearing for that other side, man? No, that we'll pass it over. That order will be continued and disposed of. No, interim order granted by this court for status quo. Let it be continued and the suit may be disposed of. That is what that pass over. Let us see if you find your friend, you ask her to come. Respondent. Since they have not filed any application for vacating, yes, it's for a hearing. I will dispose of.
I appear for the respondent in this matter, my lords.
Yes, yes. Pass over, madam. 2:30.
Please, my lords.
Yeah.
Sir, court officer, sir, 48 sir.
48 appellant advocate ಬೆಳಗಿನ ಟೈಮ್ ತಗೊಂಡಿದೆ ಸರ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಟೈಮ್ ಅಲ್ಲಿ.
ಅಯ್ಯೋ ತನ ಕುಂತ ಸರ್.
They can't take it. They have disputed the title of the respondent. And also the identity of the power.
No, suit was decreed. When you have filed an appeal?
The 10th is the delivery warrant. Terminal by. Is what.
9th, post this matter on 9th.
Matter. Serial number 7, Narasimha NS for appellate.
Yes. Paper book is. Learned counsel for the applicant has 2 weeks time to file a paper book. Yes.
Serial number 13, Niraja Karan for appellate.
Yes. Madam, this appeal is filed under section 96 of the CPC is not maintainable. Appeal has to be filed under 299. It's an MFA, not in a regular first appeal. It is an no appeal from order passed under the CPC. If it is judgment and degree passed under that CPC, appeal lies. If that judgment and degree passed under any other act, if there is an appeal provided under that act, you have to file an appeal, but it is an MFA, not an RFA. It's an MFA. There is a judgment. The MFA has been filed in some of the courts saying that no, MFA is not maintainable, it's an RFA. Then after considering that no, it is 290. See, since we have stated that 96 not applicable, appeal is provided under 299. Once it is 299 under the P&S Act, then it is a miscellaneous appeal. First appeal is only under the CPC. No, if it is converted into the suit, it is no appeal is meant. No. They said appeal to the High Court. Under 299, appeal to the High Court. That no 299 has been provided to file an appeal. Every order made by the district judge may virtue of that to be confirmed upon them shall be subject to the appeal to the High Court in accordance with provisions of Code of. See, 299 appeal that all other procedure is applicable under CPC. That's why the classification is made under the High Court. It is an MFA. There is a judgment. Therefore, you have to file an application for converted it as an MFA. All other same. Only thing is it has to be converted as MFA. There is a judgment of Justice Panindra. On that basis, after considering that, earlier order recalled and it said that it is an MFA. File an application, a memo for give that. Yes, learned counsel for appellant has filed a memo seeking conversion of this appeal into that miscellaneous first appeal. Memo is taken on record. Office is directed to convert this as a miscellaneous first appeal. Yes. What is memo?
36 purpose.
ಇದನ್ನ MFA ಅಂತ ಮಾಡ್ತಾರ ಅಂತ.
RFA number.
For statistics purpose, the appeal is disposed of.
Seshagiri KT for appellant.
And appear for the appellant. 2 weeks time is granted to comply the officer list.
47. Prakash T. Appar for appellant.
Yes. Yeah. Now they are supporting your case. Who is the contesting? Third also unrepresented. Yes. Give the facts. You are in a defendant number 1. Defendant number 1 as an appellant. Yes. 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 Well, this appeal is filed by the defendant. Under Order 41, Rule 1R of the CPC, challenging order dated 22 January 2014, passed by '39 additional city civil session judge Bangalore, IA number 1, filed under Order 39 Rule 1 and 2, whereby granted allowed that application. The convenience, parties are referred to the ranking as per the trial court. Plaintiff has filed in a suit for permanent injunction before City Civil Judge Bangalore in OS number 6422 of 2013. Contending that first plaintiff is the absolute owner of the property bearing site survey number 6 or in a converted survey number 42/1 Bangalore East Taluk. It was purchased by the first plaintiff for a valuable consideration. The absolute owner of the property first plaintiff is the absolute owner of the property in dispute. He has purchased that property from one G. Pavitra, son of N.K. Pavitra, by a registered sale deed dated 5/9/2009 for valuable consideration of rupees 3,60,000. For the date of the sale deed, the first plaintiff is in peaceful possession and enjoyment of the suit scheduled property. On the service of summons, the first defendant has appeared and filed a statement. Written statement has denied that plaintiff allegation. Along with that plaintiff, the plaintiff has filed IN number 1 under Order 39, Rule 1 and 2 of CPC. Seeking interim order of temporary injunction against the defendant or their men or agent to restrain them from interfering with the construction in the suit scheduled property. After hearing that parties IF number 1 filed by the plaintiff is allowed. The order has been passed on 22nd January 2014. We agreed by the same. Defendant number 1 has filed this appeal. This court, by order dated 16/7/2014, has granted an interim order directed the parties to maintain status quo. That order has been extended time to time. Till today, the interim order granted by this court is continued. Contesting respondents, the contesting parties are the plaintiff, who are the respondent number 1 and 2 before this court, has been served unrepresented. What is the stage of the suit now? Summons 22. Summons ಅಂತ ಹೋಗಿದೆಯಲ್ಲ. What ಹೇಳ್ದೆ? Unrepresented. The interim order granted by this court is continued till today. The suit is now posted for now at the stage of evidence. Since interim order granted by this court was operating from last 8 years. Under these circumstances, the appeal can be disposed of, modifying that order passed by the trial court and status quo order granted by this court dated so has to be continued till the disposal of the appeal, till the disposal of the suit. With that observation, the appeal is disposed of.
I appear for the respondent in this matter, my lords.
Yes. What is this case? What is the order you are challenging? 45A. The application filed under the applicant hereby partly allowed. The applicant is liable to pay the contribution salaries when it comes to 45,000 USL corporation without any interest. Where is the finding? You read issue number 1 to 6 from para 9. Mister, you don't have a file. What is that? Then you are turning the page. Whether you have any file or not, mister. Where is the file then? Why do you come to that court without the file, mister? No, if senior is there, you bring the file and read what is that case, we'll see. It is old matter. At least you read that evidence. I don't have any other matter. I can see that whether matter requires to be any consideration. Records idea.
May I read, my lords?
Yes, you can read, madam. Yes.
Lords, para 9, my lords, deals
Yes.
with issue number 1 to 6, my lords.
Yes.
It is the evidence of applicant traders that applicant unit is a partnership establishment. The applicant carrying the business of iron and steel trading using crane for loading and unloading. And no electricity power is used for this purpose. The strength of working unit is less than 20 employees. And security guards were engaged through a contractor who's paying contribution to them directly by the agency. There is no master and servant relationship between the applicant and the security guards. The coolie workers were hired for some excess work once in a way, are paid according to their work, and they are not working in their establishment. Their salaries are not regularly paid. There is no master and servant relationship. There is no manufacturing activities in the establishment. No electricity power is used for loading and unloading. The cranes are run by diesel and fuel. Attendance register and wage registers are maintained and verified by the ESI inspector. The establishment is covered under the Professional Tax and Shops and Commercial Establishment Act, and license issued by labor departments and documents are produced. Security guards are taken from G4 Security and Allied Services. Their establishment, though not covered under the ESI scheme, as their staff strength were never crossed at 19 persons, they voluntarily themselves covered the employees under the ESI Act and paying the contribution. Receipts are produced showing contribution for 17 employees during the year 2006. The establishment is not covered under the ESI Act, and documents are marked Exhibit A1 to Exhibit A15. This witness is cross-examined by Shri NS, advocate for petitioner. As per Exhibit R1, Form 1, there were 3 partners in the unit at that point of time when the inspector visited. 25 HP electric power was sanctioned, and they were using the crane for loading and unloading purpose by using power, and denied that the stone cutting machine was used by electric power. It is also denied that steel rod and steel plates were cut by using cutting machine by using the power. Exhibit R2 is the C11 notice dated 30th-10-2006. Exhibit R3 is the letter issued by the applicant on 19/1/2007. Exhibit R4 is the series of job work bills relating to cutting, and denied that September 2004, around 21 workmen were working in the applicant firm, and coolie payment was disbursed through vouchers. The coolie amount was paid to the group leader of the coolies and sometimes to the individual workers. Loading and unloading work was executed in the premises of the applicant. Repair and maintenance work was also done in the premises. RW1 evidence is that he verified the records of the applicant and also issued inspection observation slip and claimed the contribution to the applicant unit, mentioning as there were 20 employees covered under the ESI Act, they have to pay contribution accordingly. This witness is cross-examined by the applicant counsel. In the cross-examination, RW1 admitted that there was no manufacturing activities in the applicant establishment, but denied that there was no weighbridge in the establishment, and he was not mentioned the presence of the weighbridge in the establishment, since there was no necessity to mention the same in his report. He has also admitted that there was no cutting machine in the establishment and Mahazar was conducted in the spot. The previous inspector was conducted the Mahazar and submitted report to the regional office, and he has not received the copy of the same and denied that he has not at all visited the applicant establishment, and denied that sitting in his chamber he has prepared the report. And also he has stated that he has mentioned the name of employees in Exhibit R9, and he denied that Exhibit R10 is not at all connected to the applicant, and he has not mentioned the names of employees in Exhibit R10, and denied that imaginary figures are mentioned at Exhibit R10, and also admitted that R4 series is not the bills of the applicant establishment, and also admitted that as per Exhibit R3, the cuttings were done outside, and he has signed on the Exhibit R3, and he denied that since 3 partners were in the establishment, and he arrived at the figure that 20 persons are working in the unit. And he denied that Hamalis who were present at the time of inspection are counted as employees of the applicant. As per Exhibit R1, the number of employees are 12, and further cross-examined with respect to the attendance and register of the 20 persons, but alleged to be working there, and he has admitted that he has not mentioned the address of the 20 persons employees. Now coming to the evidence of RW2, who has visited the spot and Mahazar and spoken that he visited the unit for test inspection report, and at the time of inspection, he saw 21 persons were working in the month of September 2004. As per records verified by him, there was no manufacturing activities carried in the applicant unit at the time of inspection. Additional sheet was prepared as per Exhibit R11 and Exhibit R5 is the report. On verification, attendance register and the salary disbursement vouchers maintained by the applicant establishment, and he found that in the month of September 2004, there were 21 employees. This witness was cross-examined, and he denied the suggestion made by the applicant counsel with regard to the preparing of the Exhibit R11 and denied that applicant unit has not at all engaged more than 19 persons in the unit. On perusal of documents, Exhibit A1, which is a shops and establishment certificate issued by Department of Labor, registered by its 3 partners, Shri so-and-so, established in the year 1974. Exhibit A2 is the professional tax certificate under the Commercial and Shops Establishments Act. Exhibit A3 is the commercial tax certificate. Exhibit A4 is the partnership deed. Exhibit A5 is the 3 attendance registers for the period 2004 to 2007. Exhibit A6 is the balance sheet for the year 2004 to 2007. Exhibit A7 is the letter from G4 Security Services. Exhibit A8 is the receipt of ESI department given to G4 Security towards its employees in different challans. Exhibit A9 is the receipt from Provident Fund Department. Receipts are produced showing that they have paid the contribution. Exhibit A10 is the vouchers from 2004 to 2007. Exhibit A11 is the general ledger for the period 2004 to 2007. Exhibit A12 is the letter dated 11/11/2006 addressed to the respondent in response to letter issued by the ESI stating that establishment is not covered under the ESI Act and not a factory under Section 2 subclause 12 of the Act. And their concern is only establishment trading concern dealing with iron and steel materials, and it falls under Section 1 subclause 5 of the ESI Act and not a factory under Section 2 subclause 12 of the Act. They are neither using any plant and machinery to produce the goods nor doing any manufacturing products. They are trading, purchasing, and selling iron and steel materials. They're using only 20 metric ton capacity using crane for loading and unloading iron and steel material in the premises. Exhibit A13 is the order under Section 14 subclause A of the Act. The ESI Corporation has booked the account to pay the contribution as wages involved in the above said expenditure. Exhibit A14 is the copy of the registration certificates. Exhibit A15 is the copy of the inspection observation. The applicant establishment is running a business in the name and style of Messrs. Modern Traders, dealing with iron and steel trading, and the contention of the applicant is that they are the Shops and Commercial Establishment Act engaging less than 20 employees in number, and ESI Act is not covered to them, since this is not a factory within the meaning and scope of Section 2 of the Factories Act. It is further contended that the workers engaged in the establishment is loading and unloading, and they are not permanent employees of the permanent employees of the establishment. There is no master and servant relationship between the employer and employee. Therefore, they are not entitled to pay the contribution as claimed by the ESI Corporation. Now, on perusal of the documents filed by either of the parties, particularly the observation slip issued by the respondent ESI Corporation at the time of spot visit, discloses that there were more than 20 laborers working in the applicant establishment. It is urged by the applicant counsel that the list of the employees' names, addresses were not taken, and they were mobile amalis coming and going on casual basis, and their whereabouts are not known. They are the chance laborers, therefore applicant is not liable to pay the contribution as claimed by the ESI. On perusal of the muster roll, Exhibit A5 attendance register depicts there were workers working in the applicant establishment within 20 in number. So far as the attendance register for the year 2004-2005 is concerned, only for the year 2006, the muster roll discloses the employees working in the unit were 21. Exhibit A5 further depicts that in the year 2004, the total number of workers employed in every month, my lords, for the year 2004 table has been produced.
Yes.
In the year 2005, the total number of workers employed in every month, my lords, further,
Yes.
the number is below 20, my lords.
Yes.
In the year 2006, for the month of January 2021 employees were worked and 2 employees' names were strike out. However, on perusal of the muster roll, 2 employees' names were struck off, and in the attendance register, 1 employee. He was present for the work during 12/1/2006 to 31/1/2006. And 1 employee attended for the duty from 27/1/2006 to 31/1/2006. And his name was struck off, but no reasons was assigned by the applicant, either in the examination or in the affidavit of that to explanation why those employees' names were struck off. In the month of February, there were 21 employees were worked and 1 employee was present at 17/2/2006 and his name was struck off. In the month of March 2006, 20 employees were worked, and in the month of April 2006, 22 employees were worked, and 2 employees' names were struck off. And in the month of May, 21 persons were worked, and 3 persons' names were struck off. And in the month of June, 21 employees were worked, and 1 person name had erased through eraser for no explanation is forthcoming, either in the evidence or in the oral evidence in respect of deleting the names of those employees. In the month of July, 20 persons were employed, and 1 name is erased with whitener. In the month of August, 19 persons. In the month of September, 18 persons. In the month of October, 18 persons. In the month of November, 18 persons. In the month of December, 18 persons were worked. In the year 2007, in the month of January, 18 persons. In the month of February, 17 employees. In the month of March, 17 employees were worked. Now, coming to the inspection test report,
Yes.
findings of...
Hello. Now that, why I want to see that, is there any further you have to assist the court? Suppose if the employees, they have to remit that contribution every month or yearly once? Every month. If there is any employees, is the difference between that each month? How it, see, suppose here if you see, 1 month it is 21, another month is 18, then 21, 20. Some of the months they have striked off. How you will calculate? Now here what has happened?
And my lords,
Yes, 2 minutes. Wait.
please.
See, according to that, the finding of the court, see, some of the months they have shown that 21, 22, 19, 18, each month there is a difference. In some of the months, 19 is there, 2 members' name has been struck off. No, that is for the month. Yes. 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 For entire year. Subsidy month. Yes. Yes. No, that even if there is no, therefore it cannot be said that for January it is covered under that. February it cannot be. Yes. Yes. Yes, yes. No, that's what, no, in the earlier report, their contention is that there are a temporary employees, daily wages and all. For that, I think you have in a judgment saying that even one day they have work, they are entitled. Now that let us complete that reading. We will see that I will accommodate you. Let me know that what are the. Yes, you read para 21, madam. Continue that reading.
Please. And my lords, pertaining to that question, my lords, since in 2006, my lords, that happened and without any reason, names were struck off. Hence, the claim has only been partly allowed. And finally, the court has told that in the year 2006-2007, this establishment will be covered under ESI and has directed us to pay the amount for that said year, my lords, where we were not able to.
2006. No,
Please.
according to that ESI, how many years you have to be pay for the due?
My lords, the names were struck out only in the year 2006, my lords. Therefore, the court has told us to that the applicant is.
Now,
Please.
for your establishment is covered. There is no dispute.
For the year 2006-2007, my lords, because the
You
number
are
of.
having more than 20 this thing.
Please, my lords, because there was no sufficient explanation given from our
Oh,
end.
now
as to
that
what-
demand is for how many years?
My lords, they
Demand
have.
is for how many years? Yes. Now that only a point that other year you are saying that they are only a casual employees, whether they are covered or not.
Please, my lords, and my lords, those addresses, names, nothing has been furnished in the report, inspection report also, my lords, if the
No,
cross-examination
according
can
to
be.
you only,
Please, my
you
lord.
are saying that somewhere you have admitted 20 employees of security guards who are engaged through a contractor who is paying a contribution to them directly by the agency.
Please, my lords.
Then
They
you-
have. They are only, they are covered by the agency through which they have been employed, my lords, and the slips have been produced that the contribution has been paid through the agency for them, my lords.
Now 2004. 4 and 5. No, she said that 2006 and 7 is covered.
Please, my lords, and hence my lords have been directed to pay for this.
2006 and 7 they had. Now only is that 4 and 5. 4 and 5. 1 year prior. Yes. That is the, now that only a facts, whether that they have employed 20% in any month of that year. Or 5, 6. Now, according to that, your records, what are the, how many employees are there? 2004 and 5 and 6. When you have passed in a 45A order. Four and 5 salaries. Now they have produced the document to say that they have employed only 19 members. Then you have to establish how it is 21. Yes. Now that it is only a facts, you have to establish that there are more than 20 members. For that, they are giving an explanation that they have been paid by that their agents. If their agents has paying a contribution for them, there cannot be a double. Yes, ultimately they have to show that. But even if they have shown that, if there is any other employees, if it is more than 20, then also they have to pay. Yes. Now that, yes, madam, your case is that
Please, madam.
excluding that contract employees, you have employed only 19, or including that.
My lords, include contract employees, including contract employees, my lords, they have been paid by the security
No,
agency.
that will come to that point, whether
Please.
they have paid it or not, who has to show that and all.
Other than
If-
that, my lords, I have not employed anyone. Casual basis, 1 or 2 days, they have come and they have gone, my lords. In fact, the applicant themselves have stated that they have
No,
not.
that-
Please.
No, if the persons who has come one day or 2 day, they are also employees, your employees. Whether that covers more than 20 members or less than 20. No, that is the issue.
My lords,
Raspal
since
Vidya. 2004, according to you, 17, 18, 17, 17, 18, 18,
please,
18 members.
please, my lords.
These are all the employees you have employed.
Please, my
Other
lords.
than that, any other persons has worked for even single day?
Lords, I will have to take instructions specifically how many
Because-
people.
Because
Please.
your claim is that they are not covered because they have worked for 1 or 2 days. But that judgment which is cited by that Suvarna Swami says that even for 1 day if they are work,
Please,
the reason is that the day he has come to your establishment, if he suffered any injury, then he is entitled. Therefore, to covering that establishment, it is
Please.
not that how many days he has worked.
my
If he
lords, I
worked
will
one day also is entitled. Therefore, even then person is worked for 1 day is also as covered under the establishment. But only thing is that it's more than 20 members.
Please, my lords, that's why, my lords, I'll have to take instruction because in April there are 17 employees. If there are only one person who has worked, it will still be below 20. And if they have worked on hourly basis, my lords, so I will
No,
have to.
you have to
Please.
clarify 17 employees. These 17 employees are your permanent employees or what we claim that they are on only daily wages. If
No, my
17
lords,
is
they are in
your-
my muster roll. They are on
Yeah,
my muster.
your muster roll. In addition to that, you have taken more than 3 members as a daily employees, then it is covered because it is cross 20. That is the course of the matter. Now you have to answer.
Please, my lords, I will
Now
take.
that- Yes, now even that employees is covered by the reagent,
Please.
then you have to show that have they
It has
paid
been
that
produced.
contribution?
Yes, my lords, it has been paid, my lords. Page number 14, ink page number 14, my lords. Exhibit
Yes.
A8 is the receipt of ESI department given to G4 security towards its employees in different challans, my lords. It has been produced, my lords.
Yes, that we will see. If
Please,
that has been excluded,
please, my lords.
then you have to show that you have employed only 17 or more than that. Now, suppose if their record shows that they are employed only 17, then other employees has been paid by the reagent. Then for that year, it is not covered unless you have to establish producing the document. No, see, agency that is covered under the establishment. What 20? No. Now that your question is that to cover that under the tag, even if he has employed from other 3 persons, they are paid. But if it is counted for a 20, it is also covered. Yes, madam. You have to answer.
My lords, that contention cannot be taken because those people will be.
No. It is not a contention taken. It is the law. That's what he says. That. You see that what is the section?
Because those people will be counted, their head count will be counted in the agency, my lords, when the agency is being counted as being covered under the ESI Act, my lords. So if their head count is taken in that agency, my lords, for 20 to establish the being covered under the ESI Act.
No, see, even
Please.
if you are utilize their work, you need not pay for the 3 persons. But your establishment has to be covered because you have employed, you have taken a work of 20 employees. Now, suppose if he is paid regularly, if he is paying regularly, no, that's okay. Whether this yes, is there any judgment on that point? No, any judgment on that point regarding that very facts? You have any judgment? Yes, headcount. No, the fact should be even that principal employers has taken that service of that other companies. They are also established. Yes. The principal employer shall pay in respect of every employee, whether directly employed by him or by through that immediate employer. Both the employee's contribution, the employee's contribution. Yes. When if that no, if that other employers are paying, then he need not deduct and he need not pay to you. No, for that, no, private arrangement will come to the first point. Suppose if the principal employer has to pay when that other employer is not paid, if he has already paid, he need not be. If they, yes, agency. No, that they have produced that agency has paid, there is no dispute. Then what about that headcount? I'm asking whether for that I need some judgment. That is what that. See, there is no dispute risk. See, agency has paid. You have admitted. Now, whether this 17 persons has to be considered as an coming under that. Yes. We give that. Yes. That is the only crux of the matter. See, there may be a method to escape by taking only 18 members, they are taking a service of others. There may be a judgment saying that under that circumstances also it has to be covered. Yes, then you have to see that, yes.
Please, my lords.
Yes, you also.
Yeah. Yes, my lords. However, my lords, one of the questions which came.
2 points. One
Please.
is that even you are employed only 18 employees, you have taken a service of that agency. Even though agency has paid, but consideration of headcount, that you have employed more than 20% has to be considered. That is their contention.
My lords,
There may be 2 different entities.
please.
But you have
please.
taken the service of that other entity for headcount, that will also has to be considered. Second point is, even your own employees, you have a master roll of 18. You have taken a service of other temporary employees for 1 or 2 days.
Please.
Then also they are your employee. For that, I think judgment is there. Now, this point I have not seen judgment. You have to place it. Yes.
My lords,
Next week.
if I may, yeah, please, my lords, if I may submit on the first point, my lords, the Honorable
Yes.
Apex Court on 17th December, my lords, in Kirloskar versus Ramacharan, has categorically held that workers employed by the contractor do not automatically become the employees of the principal employer in absence of any other conditions laid down, my lords.
Which is that judgment?
My lords, Kirloskar Brothers Limited versus Ramacharan and others, my lords, decided on 17th December, my lords.
Yes, yes, we'll see that. Yes. Now you have understood that what are the 2 points you have to be answered.
Please,
Yes, next week. Yes,
please, my lords.
next
Great.
week. Pending
Madam, total 12 Mohan GR, madam. Madam. Total 12 ma, Mohan. ಬಾಕ್ಸ್ಗೆ ಫೈನಲ್ ಹೇಳ್ಬಿಟ್ಟು ಎಲ್ಲ ಹಾಕ್ಬೇಕು.